Welcome back to the deep dive. So if you've ever tried to secure a rental unit, especially in a competitive market, it feels less like a search and more like
What?
an intense, high-stakes financial interrogation.
Exactly.
You're handing over your most private information, stacks of cash, just for the privilege of being considered. We've pulled together a massive stack of sources today, and we're focusing primarily on navigating California tenancy law and the crucial, often overlooked legal rights that define that whole landlord-tenant relationship.
Right. And that's our whole mission today.
Yeah.
To give you sort of the operational blueprint. We want to cut through the complexity, the bill numbers, the fee caps, the specific dates, and really equip you with the critical knowledge you need to succeed.
It seems like it's a dual responsibility.
It is. The landlord-tenant relationship is a two-way street, and with some significant new laws coming into effect in 2025, knowing the rules is really your ultimate shortcut to success. Specifically, we're looking at how the process is shifting from a landlord's subjective choice to a documented, almost first-come, first-served queue.
Okay, let's unpack this journey, starting right at the beginning. That exhilarating but also very expensive first step of finding the unit.
Right.
It's not just about the sticker price on the monthly rent. You have to consider the total liability. That includes utilities, of course, but also all the other fees and deposits, security, application, holding fees, maybe pet deposits.
And the context matters so much before you even look at an application. First, you need to understand the local regulatory environment. Is the property in a city like, say, Los Angeles or San Francisco that has its own local rent control ordinances?
Because those can offer even more protections.
Often much more robust protections, yeah. And second, you're deciding on the basic structure of your tenancy. Do you want the security of a fixed-term lease, a guaranteed 1 year, or do you want the flexibility of a periodic month-to-month tenancy?
And we should bring up accessibility right away. For any prospective tenant, you have to consider if the unit is physically accessible for persons with disabilities or if the landlord has to let you make reasonable modifications at your own expense.
Absolutely. Now let's talk about the business of the search itself, because some tenants use what are called prepaid rental listing services. These are companies that charge you a fee up front to give you lists of available properties.
Okay, and the sources note that in California, these services have to be licensed by the Department of Real Estate, and they have clear obligations.
Yes, do.
What are those obligations? Because this feels ripe for abuse.
Absolutely, and that's why the main protection is performance-based. The service must provide you with at least 3 currently available rentals within 5 days of you signing your contract.
Okay, only 5 days.
And the contracts themselves can only run for a maximum of 90 days. If they fail to hit that minimum of 3 available units, you are entitled to a full refund.
As long as you request it in time.
Provided you request it within 15 days, yes. It's a key consumer protection against, being sold a stale list of unavailable apartments.
That's a powerful tool. But let's shift to the application itself. When you hand over that paperwork, you're also handing over money for the screening. So what are the legal limits on that application screening fee?
This is a critical insight. Legally, that fee cannot be a profit center for the landlord. It can only cover the landlord's actual out-of-pocket costs for the background and credit checks, plus the reasonable value of the time spent gathering that information.
And there's a maximum fee, right?
There is, and it's adjusted annually based on the Consumer Price Index. As of December 2023, it was $62.02.
That specific annually adjusted number is fascinating. It's so precise.
It has to be. That precision is what ensures the landlord operates without a profit motive. It curbs that historical practice of, collecting dozens of application fees just to profit off rejected applicants. If they charge you, the cost has to be itemized, and any unused portion must be returned to you.
And here's where it gets really interesting, because the state is now legislating to enforce the spirit of that law, preventing the collection of unnecessary fees altogether. We're talking about Assembly Bill 2493, which we can just call the Q Law, and it's coming in 2025.
Exactly. The Q Law fundamentally changes the power dynamic. Starting next year, a landlord has to provide their screening process, their criteria, to the applicant in writing.
In writing, okay.
And critically, they must consider completed applications in the order they were received. They have to approve the first applicant who meets their established criteria.
So just to crystallize that for the listener, the landlord is now obligated to stop the whole process once they find the first qualified applicant. It moves from a subjective choice among many to an objective first-come, first-served queue.
Precisely, a queue. and the protection against unscrupulous fee collection is strengthened. A landlord is prohibited from charging that screening fee if they knew or should have known that no unit was available within a reasonable time. They can't just keep running checks indefinitely.
So you get past the initial hurdles, and then comes the screening gauntlet, that deep dive into your financial past. What exactly are landlords scrutinizing in those credit reports?
They're looking for risk indicators, really, trying to predict future behavior. This includes a history of late payments, any record of bankruptcy, and especially past unlawful detainer or eviction lawsuits.
An unlawful detainer, that's just the legal term for eviction, right?
It is, and landlords consider it a massive red flag.
We do have a specific detail in the sources about COVID-19 related evictions, though.
We do, and it's important. To protect renters impacted by the pandemic, unlawful detainer actions filed in California between March 2020 and September 2021 related to pandemic rental debt were legally masked.
Meaning they shouldn't even show up.
That information should not appear on tenant screening reports and cannot be used as a basis for denial. And of course, your credit score, that numerical summary, is just the overall gauge of your financial risk. And yes, landlords overwhelmingly prefer applicants with a history of timely payments.
But what if you're new to the country? Or maybe a young professional, and you just haven't had time to build up a credit score yet? This lack of history is a huge barrier for so many qualified renters.
It is a massive hurdle, but there are mitigation strategies. Landlords often understand that a newly issued Social Security number results in a blank credit report, which is very different from a bad credit score.
So what can you do?
Well, community feedback suggests a few pathways. You can offer a higher upfront payment, say 2 or 3 months of rent or security deposit as a kind of buffer. You could also focus your search on smaller, private landlords who are often more flexible than the big corporate property management firms.
Or you could just rely on really strong, verifiable income. Tell me more about how a high-income contract can substitute for credit history.
Right. If you're an established professional, for instance, with an employment contract for a $165,000 salary, that high income can effectively serve as a substitute credit history.
Because the risk is lower.
Exactly. The risk to the landlord is now quantified not by your past payment behavior, but by your guaranteed future earning power. That high salary shows an extremely low probability of future default, and that can often outweigh a lack of, say, 3 years of credit history.
And if that's not enough, you look for financial backing, a cosigner or a guarantor. We often hear those terms used interchangeably, but there's a crucial legal difference here that everyone really needs to understand.
This is maybe the most vital nugget of knowledge for anyone asking a friend or family member for help. A cosigner agrees to take on legal responsibility for the debt immediately alongside the primary renter.
So if the renter misses one payment,
the cosigner is liable, and the debt appears on the cosigner's credit report right away.
Wow. So the cosigner is essentially a second tenant just for debt purposes. Why would a landlord ever agree to a guarantor instead?
Because a guarantor offers a softer liability. They only assume financial responsibility if the renter falls into total default. That means failing to repay the lease entirely, usually after an eviction or abandonment.
And it doesn't hit their credit report.
Generally, no. The guarantor arrangement doesn't impact their credit report unless that total default actually occurs. Landlords, they often push for cosigners because it provides immediate, easier access to funds if the rent is late, but the safest bet for the person offering financial backing is always to be the guarantor.
That is a tremendous distinction. Now, shifting toward how we build that credit, we have more good news from California slated for 2025 with Assembly Bill 2747. Which we can call the positive reporting rule.
This is a major win for tenants. Landlords will be legally obligated to offer tenants the option of reporting their positive rental payments to at least one nationwide consumer reporting agency.
The tenant has to opt in, though.
The tenant has to opt in, yes, and the landlord can charge a small fee, but it can't exceed $10 a month or the actual cost, whichever is less. This helps tenants build a valuable financial history just by doing what they're already doing. Paying rent on time. It turns monthly rent into credit equity.
Beyond credit scores, we have to talk about fair housing laws. Landlords are prohibited from using certain criteria to deny an application, creating a really expansive list of protected classes in California.
Oh yeah, California law is very broad. Landlords cannot take adverse action against you based on race, religion, sex, gender identity, age, disability.
Familial status, so families with children, or if you're pregnant.
Right, or national origin. And crucially, they cannot discriminate based on source of income, which means they can't refuse housing just because you use a rental subsidy or a voucher.
And the sources are also very explicit about immigration status.
Yes, landlords may not inquire about an applicant's citizenship or immigration status, and they definitely can't use threats of disclosure to influence a tenant to move. That protection is absolute.
It's fascinating to compare California's broad protections with local rules designed specifically for affordable housing, like those in Chicago under their Affordable Requirements Ordinance, the ARO. Why bring up Chicago?
Because the Chicago rules, while they're local, they show us exactly how these legal protections are operationalized to ensure a truly individualized assessment, which is really the gold standard for fairness.
How so?
For affordable units in Chicago, landlords cannot deny an application based solely on credit score or history. They have to review the factors individually.
And their rules on criminal history are extremely specific, aren't they?
They are. Criminal history checks can't even be performed until the applicant is pre-qualified on other grounds. If they check it, they can only consider convictions from the previous 3 years, and they have to look at the nature and severity of the crime, the time that's passed, and any evidence of rehabilitation.
And they exclude arrests that didn't lead to a conviction.
Exactly. They explicitly exclude non-conviction records like arrests, juvenile records, or sealed convictions from consideration. This ensures that past mistakes don't become a lifelong disqualifier.
Moving back to safety protections in California, the law is very clear about protecting survivors of violence and abuse.
Absolutely. The sources highlight that landlords are prohibited from taking adverse action against an applicant who previously broke a lease or requested a lock change because they were a victim of domestic violence, sexual assault, human trafficking, stalking, or elder abuse.
And the mechanism for immediate protection is strong.
It is. If you are a survivor, you can terminate your lease early without penalty, although you might owe 14 days of rent after providing notice. And what's more, upon a written request with proper documentation, like a restraining order or police report no more than 180 days old, the landlord is required to change the locks at their own expense.
Okay, you've been approved. Now it's time to sign the contract. This is where understanding the terms of the lease becomes paramount, especially the length of the agreement.
You really need to know the commitment. A fixed-term tenancy offers security. The rent can't be raised during that period, but it carries that significant liability risk. If you move out early, you could be on the hook for the remaining rent until the landlord finds a replacement.
Whereas a periodic month-to-month lease gives you flexibility.
A lot of flexibility, but it means the landlord can increase the rent with proper notice.
We also have a powerful language protection law. If the rental agreement was negotiated in a language other than English, specifically Spanish, Chinese, Tagalog, Vietnamese, or Korean,
the landlord has to provide a written translation of every single term before you sign the agreement.
and that's a huge consumer right.
It's massive.
Yeah.
If the landlord fails to provide that translation, the tenant has the right to legally cancel or rescind the agreement entirely. It prevents tenants from being locked into terms they didn't fully comprehend in the negotiation.
And as we move to legally required disclosures in California, it feels like the landlord has to hand over a full and often unsettling history of the property before you even pick up the pen.
They absolutely do. These disclosures cover environmental and safety issues like lead-based paint if the unit was built before 1978, asbestos, disclosure of periodic pest control treatments.
And some of the others are pretty surprising.
Oh, yeah. They have to disclose if they know of any bed bug infestations, and they must provide notice if the property was subject to a prohibition order because of methamphetamine contamination.
And then there are the location and history disclosures, including some macabre facts.
That is correct. A landlord has to disclose any death that occurred in the unit within the last 3 years, including the manner of death, though the law explicitly carves out an exception, saying they are not required to disclose deaths related to AIDS or HIV.
That's very specific.
And they also have to notify you if the unit is within 1 mile of a closed military base where ammunition or explosives were previously used.
Let's discuss utilities, because this is where costs can often explode. If a property has shared utility meters, that has to be disclosed before signing, correct?
It must. If a single meter serves multiple units or common areas, the landlord must disclose that arrangement before the lease is signed and agree in writing on how those costs are apportioned.
And this is so important because otherwise you could end up paying for your neighbor's laundry.
Or the common area lighting, yeah. The law ensures they can't charge you more than the actual cost of the utilities used. It prevents them from profiting off your bills.
Let's move to the day-to-day realities of living in the unit, starting with how you pay rent. Landlords are limited in demanding specific payment forms.
Right. They cannot typically require you to pay rent exclusively in cash or using an electronic funds transfer system unless you have a history of a dishonored check or have previously been served a 3-day notice to pay or quit.
And if you do pay cash,
If you pay with cash or a money order, the landlord is legally required to provide a written receipt and a new consumer protection starting in January 2025. Landlords cannot charge you a fee for paying by check.
and those dreaded late fees, they often feel so punitive.
And they cannot be punitive. Late fees are only allowed if the actual cost to the landlord, the administrative burden, for example, is difficult to calculate, and the fee is a reasonable estimate of that cost. The key principle is that the fee can't be so high that it amounts to a penalty designed to coerce payment.
Moving on to rent increases, the Tenant Protection Act in California, AB 1482, provides a critical safety net for covered properties.
It does. For properties covered under AB 1482, the annual increase is capped at 5% plus inflation, or 10%, whichever is lower. For most people listening, this means your landlord can't legally hit you with a massive, unexpected rent hike. It provides necessary predictability.
And even for properties that are exempt from that state cap, proper notice is still required.
Oh, yeah. 30 days notice if the increase is 10% or less, but a full 90 days notice is mandatory if the increase is over 10%.
Finally, let's talk about privacy and the limits of landlord entry. This is one of the most fundamental rights a tenant has.
The law is incredibly specific here. A general inspection is explicitly not a permissible reason for entry. A landlord may only enter the unit for defined permissible reasons, like responding to an emergency, making agreed-upon repairs, or showing the unit to prospective tenants or purchasers.
And what about notice?
For most non-emergency entries, the landlord must provide 24 hours written notice, and the entry has to take place during normal business hours,
Which the law defines
as 8 a.m. to 5 p.m. 7 days a week. If the landlord violates this, you absolutely have the right to deny them entry. So to wrap this all up, remember the 3 most practical takeaways. First, always document the condition of the unit when you move in. Use an inventory checklist. Take dated photos. This protects your security deposit.
Must do.
Second, know that deductions from your security deposit are only allowed for damages or cleaning beyond normal wear and tear. Your landlord can't charge you to repaint after 5 years just because you use the walls. And third, if the property becomes uninhabitable, you have legal remedies like repair and deduct. Paying for the repair yourself and subtracting it from the rent, or even rent withholding until the repairs are made.
This has been a deep dive into the legal blueprints of tenancy. You now possess the critical knowledge to navigate the application process, challenge unfair fees, and protect yourself throughout a tenancy. You are no longer just an applicant. You're an informed consumer, armed with the knowledge of laws like the Q law and the positive reporting rule.
Right.
We've spent a lot of time today seeing how vital a credit history or guaranteed income stream is for a smooth rental application. However, under new laws, like California's 2025 positive reporting option and Chicago's individualized credit review, the system is slowly starting to recognize something, something far more valuable than an abstract credit score.
And that is
A documented, reliable history of paying rent on time. So the question we leave you with is this. How can we, as consumers and tenants, continue to push the rental market to universally value real-world tenancy performance at a monthly on-time rent payment over the more complex and often more biased abstract financial metrics of the traditional credit score? Something to think about as you use these new systems to your advantage.